Hiroshi, I have filed an application on 10th January, my lords. Application to bring submission filed before the ITAT. In this application, Your Lordship, I have referred to certain judgment
Yes.
which were very crucial for decision in the matter, Your Lordship.
Covering memo.
Application, covering memo for application to bring subsequent submissions filed before the ITAT.
Yes.
I say, my lords, these submissions were not considered by the ITAT while deciding the matter. A legal issue was involved in this matter. Even
You have received the memo of appeal
Yes, Your Lordship.
along with annexures.
Yes, Your Lordship.
in this application,
Yes, none. What is the matter, Mr. Agarwal?
my lords. Certain, Your Lordship, business transactions were treated by the department under section 2, subsection 22, subclause E of the Act, my lords. Under this provision, Your Lordship, the loans and advances were required to be treated, my lords. I have reproduced the provision, Your Lordship, at page 5 of my memo of appeal.
So this point is not covered by any decision. Substantial question that you have proposed.
In fact, Your Lordship, I have referred certain issues before the tribunal, my lords. That is by way of submissions, Your Lordship, filed.
Your Lordship, all the three authorities, while making observation, they have, my Lord, relied upon certain judgments, Your Lordship. And in the light of those judgments, my Lord, the amendments which were made by the assessee before Commissioner of Income Tax Appeals, as well as, my Lord, before the Income Tax Appellate Tribunal, they have been, my Lord, they have been decided. Now, Your Lordship, here the issue is what they are saying. Initially, my Lord, they were disputing applicability of section 222E. They said, my Lord, that in their case, the provision of section 222E is not applicable because
What is that?
that, my Lord, is deemed dividend.
My lords, I have produced the provision at my memo of appeal, my lords.
No, my Lord, kindly, my Lord, the brief, my Lord, the facts is like this. Initially, my Lord, before the assessing officer, their submission was, my Lord, that whatever accumulated profit they had generated up to the end of financial year has to be taken into consideration for, my Lord, the purposes of calculating dividend. This was negated by the
No, this
assessing
is
officer.
220.
222E.
Subsection 22, my lords. 2, subsection 22.
Section 20. Section 2.
2,
My Lord, 222E.
within bracket 22, then within bracket small e, my lords.
Small
E.
e. Yes.
Any payment by a company, not being a company in which the public are substantially interested, of any sum, whether as representing a part of the assets of the company or otherwise, made after 31st day of May 1987. This is important, my lords, by way of advance or loan to a shareholder, my lords. Being a person who is the beneficial owner of share, not being share entitled to a fixed rate of dividend, whether with or without a right to participate in profits, holding not less than 10% of the voting power, or to any concern in which such shareholder is a member or a partner and in which he has a substantial interest. Hereafter, in this clause referred to the said concern or any payment by any such company on behalf or for the individual benefit of any such shareholder to the extent to which the company is either case possesses accumulated profit. My lord.
So, Your Lordship, what their submission initially, my Lord, before the assessing officer was that, my Lord, whatever accumulated profit they have generated, my Lord, and that has been taken into consideration by the assessing officer up to 1st of April, that has to be, my Lord, by the end of that financial year up to 31st of March, my Lord. Now, kindly see, my Lord, how the assessing officer has, my Lord, dealt with this issue. My Lord, they themselves, they have diluted, my Lord, their own ground. Initially, my Lord, they were challenging the applicability of section 222E. which, my lord, both the appellate authorities, they have held, my lord, yes, section 222 is invocable in your case. Now, my lord, kindly see the ground, my lord. First of all, your lordship, kindly come down to page number 14 of the assessment order. Issue is absolutely threadbare discussed, my lord, by all the three authorities.
What is the final verdict by the tribunal?
My lord, the final, my lord, finding of the tribunal, my lord, tribunal has given them the benefit, my lord, of more than 7.5 lakhs.
That has been announced by the CIT appeals, my lord.
Sir,
CIT appeal announced
sir,
that was.
either he should, my lord, may make submission or he should allow me to make submission, your lordship.
Mr. Agarwal, you tell us what was the finding by
My lord.
the tribunal?
The finding of tribunal is at my lord's page. My lord.
Page 76, my lord, paragraph 6.
Yes, para 8, my lord, 78, page 78, my lord. We have heard both the parties and perused material on record. We find that it is not undisputed that the provision of deemed dividend are attracted in the case of assessee
This is very important.
having substantial interest in the firm as well as company. However, the only dispute lies with respect to quantum of amount and nature of amount received by Messrs. Gulmohar Traders from Messrs. Survin Marketing Private Limited. According to the council, the amount of rupees 16 lakhs after set off of opening balance of rupees 10 lakh, the amount of rupees 16 lakhs should be considered as deemed dividend, being express loan or an advances, and an amount of rupees 8.60 received on 15/2/2007 could be considered in the nature of deemed dividend. Thus, an amount of rupees 14.60 is only deemed dividend as per submission of the learned counsel for the assessee. Whereas the learned CIT appeal was of the view that accumulated profit at the end of the year at rupees 22.59 is to be considered deemed dividend under section 222E of the Act. Whereas the AO has considered the amount of rupees 12.29 being accumulated profit as opening balance of the year as deemed dividend. On perusal of page 9 of the paper book, which is a copy of ledger account, we find that advances shown as payment on behalf of the assessee towards license fee are also not in the nature of deemed dividend payment on made directly to third party on behalf of assessee. Therefore, we are of the view that addition of rupees 14.60 being deemed dividend is taxable in the hands of the assessee for the year under consideration. Hence, addition of rupees 14.60 is confirmed and balance addition of rupees 7.99 is deleted. We are also of the view that addition on account of deemed dividend is to be made out of accumulated profit, which is in this case is at rupees 22.59. However, the deemed dividend is only at rupees 14.60, hence addition to that extent is confirmed. My lords, this submission, my lords may have application filed before my lords. The submissions made before the ITC was there. The contention of the assessee in this appeal, my lords.
So this balance addition of 7999969
Bas.
is deleted.
Yes, that was enhanced by the CIT appeal, my lords.
Huh?
That was enhanced by the CIT appeal also.
Deleted from?
From, my lord, addition which was made under the head, my lord, dividend.
All right.
Distribution of dividend. In fact, my lord, 10 lakhs was the addition which was made by the Commissioner Income Tax Appeals.
So you are challenging this confirmation of this 14 lakh 60.
Yes, Your Lordship.
On what ground?
My lords, this submission made by the assessee before the ITT, my lords. My lords may have the application I have filed. Along with this application, I have filed these submissions before the ITT. I have referred to certain judgment of Supreme Court as well as of Madras High Court as well as this honorable court, which shows that this is not a loan or advances, Your Lordship. The judgments referred by Your Lordship has never been considered by the ITT while filing, while deciding the appeal matters.
Which judgment?
My lords may have application filed by me, my lords.
Oh, yes, it is there.
Yes, Your Lordship. May I read, my lords? First page, my lords.
First page, which judgment are you pointing?
Yes, Your Lordship, there is. The CIT versus CP Sathi, my lords. This is of Supreme Court. And of that is reported in 83 ITR 170.
CIT versus?
CP Sathi.
The first judgment pertains to some Oriental Insurance Company versus Deputy Commissioner of Income Tax.
Yeah, Your Lordship, submissions, my lords, may I have my submission before the ITAT.
At which page are they?
Along with this application, my lords. My submission is only there. That is,
You said there is a covering memo.
yes, Your Lordship. That
It
is,
contains judgments only.
this
There are no
contains,
submissions.
this is the first page, Your Lordship. First page, my lords, may I have first page.
Yes.
My lords, fine?
Yes, yes.
Yes, contention of the SSA, my lords.
Hmm.
Section 222 is deeming provision and to be construed strictly. That is was held by also Supreme Court in the case of Sathi, CP Sathi Madaila, my lords. This issue was never been discussed by the ITT, Your Lordship. Further, Your Lordship, we have submitted that the legal fiction therefore would operate only with the field or the purpose for which legal fiction is created. Thereafter, Your Lordship, loan was discussed by this honorable court in the case of Lakshmi Chand Muchal, 43 ITR, my lords. That was also not considered whether the transaction between the SSC and the companies are in the nature of loan or advances. These submissions were never been considered by the ITT. No appreciation on this.
You are pointing out the definition of loan.
Yes, Your Lordship, that has never been discussed by the IT matters. ITT.
When were these submissions made?
19/9/2016, my lords.
Does it find mention in the order?
No, Your Lordship.
They must have gone by the pleadings. Pleadings and the argument.
Yes, Lordship. They have certain judgments has been considered by them, but yet crucial judgments are never been considered by the ITT.
What difference would it have made?
Your Lordship, if my submission were considered by the ITT, then ITT might be taken a different view that these transactions between the SSC are not in the nature of loan and advances and will not fall under the purview of section 222E.
Where is the memo for
Above minutes?
before the tribunal?
Minutes. Page number 40 minutes. A4.
40.
40 minutes.
Where is the submission in the appeal?
Grounds of appeal are there, my lords. There is no submission on merits. We have then filed a paper book. That is starts from page 43, my lords.
Ground में कहाँ है?
The grounds of appeal. Page 42. In support of those grounds, we also have this submissions.
क्या कहना है आपका मिस्टर लाल?
Sir. Sir, kindly come down to sir annexure A1 page number 13. From here, sir, actually the story starts.
So ये assessment order के ऊपर
अरे sir,
जाते हैं, sir.
बताइए.
Sir, kindly come down to sir paragraph number 2. If it starts from the assessee individual having income from salary and business income during the course of assessment proceeding in the case of Messrs. Shorewin Marketing Private Limited for assessment year 7-8, it was found that the assessee company has given a loan advance of rupees 41,44,109 to Messrs. Gulmohar Traders. The company Messrs. Shorewin Marketing Private Limited has reserve and surplus amounting to rupees 22,59,970. Now, kindly, my lord, this amount may kindly be taken into consideration because this is the amount which has been accepted, my lord, by the Income Tax Appellate Tribunal. And based upon this amount only, my lord, the benefit of doubt, my lord, has been extended in favor of assessee, whereby, my lord, more than 7,60,000 has been, my lord, the benefit of my lord, this addition has been deleted by the ITAT. Now, thereafter, your lordship, consisting of opening balance of rupees 12,29,565 and profit during the year amounting to rupees 10,30,404. During the assessment proceeding, white query dated so and so, assessee was asked to furnish complete detail of advance. On the reply dated 2012, assessee stated that both Messrs. Gulmohar Traders and Messrs. Shorewin Marketing Private Limited are in the same business, and the amount standing as closing balance should not be seen as advance given, but it is outstanding against the day-to-day business. Now, my lord, page number 14, the assessee submission has been considered and found not acceptable, for the reason that on going through the ledger account of Shorewin Marketing Private Limited in the books of Gulmohar Traders, it can be clearly noted that most of the transactions are in the nature of payment made for expenditure on behalf of the other one. Paying expenses of each other is in no way relates to day-to-day business transaction. The transactions are not at all in the nature of some trade. The assessee himself has accepted in his reply that Mr. Anil Arora is partner of Gulmohar Traders, having 25% share and also shareholder in Shorewin Marketing Private Limited, having 50% shareholding. Further, there is outstanding of rupees 41,44,109 in the books of Gulmohar Traders payable to Mr. Shorewin Marketing Private Limited. All these facts have been accepted by the assessee, and there is no doubt. Since the assessee, Shri Anil Arora, has substantial interest in the company as well as in the firm, provision of section 222E for deemed dividend on advance given is applicable. On perusal of balance sheet of the company, it has reserve and surplus of rupees 12,29,565, whereas advance amount is of rupees 41,44,109. The amount of deemed dividend has to be received to the tune of reserve surplus only, and hence deemed dividend will be rupees 12,29,565. In view of the above, the provisions of deemed dividend is clearly attracted in the case of Shri Anil Arora as per the section 222E of the Income Tax Act. Therefore, an amount of rupees 12,29,565 is added, my lord. It was added, and total income, my lord, was calculated, my lord, to the extent of 13,38,702. Now, kindly see, my lord, when they filed appeal, my lord, before the Commissioner of Income Tax Appeals, their memo, their ground of appeal, my lord, at page number 17. Straightway, my lord, to the ground number 5. Page number 17.
Yes.
May I read, Lordship? That on the facts and in the circumstances of the case, the learned AO erred in not justified in making addition of rupees 12,29,565 on account of deemed dividend under section 222E. The said section has no application in the case of the assessee. This was, my lord, their initial stand, my lord, and therefore the addition is unsustainable in the law, and on facts, hence the same is deleted. Now, your lordship, this issue has been decided at paragraph number 5. Page number 26 by Commissioner of Income Tax Appeals. Internal page 8, your lordship. The bottom, my lord. Paragraph 5, then my lord 5.1. While making the impugn addition of rupees 12,29,565 being deemed income under section 222E of the Act, the assessing officer observed as under. Now, my lord, this was the observation which was made by the AO. Now, 5.2, my lord, the AR filed the following submission during the appellate pilot proceedings. This was the submission, my lord, which was filed, and ultimately, my lord, paragraph 6 The finding has been recorded, my lord, by the Commissioner Income Tax Appeals, your lordship. Paragraph 6 starts from, yes, at page number 30. And very threadbare, my lord, elaborately, every aspect of the assessee has been considered. I have considered the facts on record, the submissions made by learned AR of the appellant and the findings recorded by learned AO as per the assessment order. The undisputed facts in the case are summarized as under. The appellant holds more than 20% shares in a company, namely Messrs. Sherwin Marketing Private Limited, which is the finding recorded by AO also, which has advanced loan to a partnership firm, namely Messrs. Gulmohar Traders, where also the appellant holds more than 20% interest. Number 2, the lending company is not in business of money lending. Number 3, public is not substantially interested in the said company. Number 4, the accumulated profit in the company under consideration at the end of the previous year stood at rupees 22,59,699. This was the figure, my lord, which they have shown as their my lord, reserve and surplus, my lord. The arguments of the appellant can be summarized as under. These were business transactions between the two concerns, and the account between the two is in the nature of current account. For invoking the provisions of section 222E, there must be an advance or loan. Advances given in the ordinary course of business cannot be treated as loan and advances. Now, my lord, they have reproduced, my lord, the section in paragraph 6.2. In this regard, it is important to consider the provisions of section 222E, which are reproduced as under. Now, he says, my lord, any payment by a company not being a company in which the public are substantially interested of any sum, whether as representing a part of the assets of the company or otherwise, made after 31st day of May 1987 by way of advance or loan to a shareholder, being a person who is the beneficial owner of shares, not being shares entitled to a fixed rate of dividend, whether with or without a right to participate in the profit, holding not less than 10% of the voting power, or to any concern in which such shareholder is a member or a partner, and in which he has a substantial interest in the company, hereinafter in this clause referred to as the said concern, or any payment by any such company on behalf of, for the individual benefit of any such shareholder, to the extent of which the company is either case possesses accumulated profit, but dividend does not include. Any advance or loan made to a shareholder or the said concern by a company in the ordinary course of its business, where the lending of money is a substantial part of the business of the company. Now, explanation 1, my lord, it says the expression accumulated profit, wherever it occurs in this clause, shall not include capital gain arising before the first day of April 1946 or after the 31st day of March 1948 and before the first day of April 1956. Explanation 2, my lord, the expression accumulated profits in subclause A, B, D and E shall include all profits of the company up to the date of distribution of profit referred to in those subclauses, and in subclause C shall include all profits of the company up to the date of liquidation. Now, my lord, this is not applicable. Now, expression 3, my lord, for this purpose of this clause, concern means a Hindu undivided family or a firm or an association of persons or body of individuals or a company. B, a person shall be deemed to have substantial interest in a concern if he is at the time during the previous year beneficially entitled of not less than 20% of income of such concern. Section 232 of the Income Tax Act defined substantial interest in a company as person who has substantial interest in the company. In relation to a company means a person who is the beneficial owner of shares, not being shares entitled to a fixed rate of dividend, whether with or without a right to participate in profits, carrying not less than 20% of the voting power. A perusal of aforesaid provision shows that it provides for an inclusive definition of dividend. It is applicable with respect to loan and or advance made by a closely held company in any of the following situations. Now, these are the two situations, your option. To a shareholder of a lender company, if such shareholder owns shares carrying at least 10% voting power in the lender company, or to a concern, company or firm or HUF or AOP in which such shareholder has at least 20% beneficial interest. Now, situation C is any payment by such company on behalf of for the individual benefit or any such shareholder. Number two, loan or advance given in any of the three situations as discussed above would constitute dividend to the extent of accumulated profits in the lender company. One of the exceptions of this clause is where substantial business of the lender is money lending and it has given loan / advance in the ordinary course of business. Now, my lord, they say, from the undisputed facts as detailed above, it is clear that loans were given by the lender, a closely held company, not being a widely held company as defined in section 218 of the Act, to another closely held another held group concerned being the borrower. The appellant holds more than 20% share, substantial interest each in the borrower as well as in the lender company firm. Therefore, the test of lender company and the shareholder required as per section 222E is clearly satisfied. The test of concern is also satisfied as the appellant holds substantial interest in both the entities. I therefore hold that the case squarely falls within the four corners of situation B described above. The use of word, well, my lord, their basic submission was that section 222E is not applicable in their case. Now, my lord, kindly see what further has been recorded, my lord, by the CIT appeals. The reference of either case in the clause also lends credence.
कहाँ पढ़ रहे हैं आप?
My lord, sorry. I therefore hold, my lord, page 33. My lord, page 33. I therefore hold that the case squarely falls within the four corners of situation B described above. The use of word or after each situation described in section 222E leaves no doubt that section 222E contemplates three independent situations in which the provisions may get attracted. The reference to either case in the clause also lends credence to the fact that there are more than one situations contemplated in section 222E. A simple interpretation of section 222E provides the above result as the law on this proposition is not very well founded. It is also relevant to understand the historical background of section 222E of the Act. My lord, I skip this. And I will, my lord, straightway come to my lord, paragraph number 6.7, page number 35. As highlighted above, the definition of dividend in section 222 is an inclusive definition. In other words, the definition is not exhaustive. In addition to the meaning of dividend in common parlance, like distribution of profits by way of dividend by the company to its shareholders, it deems that in certain situations, even though the distribution / payment are not be dividend in common parlance, but the statute deems such distribution / payments to be dividend. By providing an inclusive definition of the expression dividend, section 222 brings within its purview the items which may not ordinarily constitute the payment of dividend. By doing so, the payment has expanded the parliament has expanded the ambit of the expression dividend by providing an inclusive definition. The proposition of law is no longer res integra as held by Supreme Court in the following cases. Now, my lord, these are the judgments which were relied upon, my lord, by the Commissioner of Income Tax Appeals. And ultimately, your lordship, the Commissioner of Income Tax Appeals, my lord, at paragraph number 6.10, 6.9 onwards, as mentioned earlier, my lord, page number 37. As mentioned earlier, the provisions of section 222E have been brought into the Act for thwarting the wrong practice indulged into by closely held companies to distribution of accumulated profit, either directly or indirectly, as loans or advances rather than as dividends, leading to avoidance of tax on such distribution of profits. In the instant case, there is no dispute about the fact that in the relevant previous year, the appellant was a substantial shareholder in the company's Messrs. Shorevin Marketing Private Limited, in short, SMPL. Admittedly, SMPL made various payments on behalf of the partnership concerns, namely Messrs. Gulmohar Traders, and the debited amount of the said firm in the books. The appellant has described this as a current account, a proposition which is not acceptable. Firstly, because the lender company is not in the business of money lending, and secondly, the fact that payment was directly made to the third party does not change its character and it still retains the nature that is loan and advances. The plea of direct payment and not making a payment of the borrower is a ploy to thwart the provisions of law and an escape route from the rigors of Section 222E of the Act. The above findings clearly indicate that the impugned amount paid by the group company to or on behalf of the partnership firm were in the nature of loan and not trade advances given during the normal course of business. It has nowhere been claimed that giving loans and advances was a normal business of the company under consideration, nor any transaction relating to the business has been shown. Though it has been claimed but not established either by any document or any evidence or by conduct that the transactions were related to the business. It has been merely stated that since the transactions were in the form of current account, they were of business nature. In view of the above said factual position, it is held that the appellant has not been successful in controverting the findings of the AO on this issue with any independent contemporaneous evidence, and therefore I see no reason to interfere with the action of the AO on this ground in treating the amounts advanced by the group company SMPL to the partnership firm as dividends in the hands of appellant. However, learned AO has treated only an amount of rupees 12,29,565 as a deemed dividend under Section 222E, being amounts paid to SMPL to GL. It is seen from the copies of the account of the two concerns and other details furnished by the appellant that the former had advances a sum of rupees 31
All right, we've heard it.
Now kindly see, my lord, how this has been dealt, my lord, by the ITAT. Your Lordship, Your Lordship, now kindly, my lord, the grounds of appeal. Your Lordship.
Indore bench of the tribunal's orders do come here.
Yeah, yeah.
Tribunal order passed is at Indore.
Yeah.
Do they come here?
Assessing officer is of Bhopal.
Assessing officer is?
It's from Bhopal.
It's from Bhopal, my lord.
That is why.
Yes, my lord.
Right.
Now, your Lordship, the grounds of appeal, my lord, which was raised before the Income Tax Appellate Tribunal, which was, my lord, just read, my lord, by my learned friend, my lord, is at page number 40. Is that page number, your Lordship, 44. 42, your Lordship. Now, ground number 3 and 4. Ground number 3 may kindly be seen that on the facts and in the circumstances of the case and law, the transactions between the company Messrs. Sherwin
Here, Mr. Agarwal, you are not disputing the applicability of 222E.
My lord, they have disputed. They have disputed before, my lord.
The grounds they have said so.
My lord, in the grounds they have said, my lord, and they were disputing all throughout, your lordship.
The applicability of this 222E.
On the premise, my lord.
No, they say that they don't dispute.
No, they have disputed.
Page 5.
They have disputed.
Page 5, padhi.
In page 5 of your lordship.
On this appeal.
Memo of appeal. This is what, my lord, I am saying. I am raising objection. There you were saying applicability of 222E is not applicable in your case. Now you considered yourself, my lord. Now you say that the 222E section, the way it has been applied, my lord, is not in accordance with law. Now, my lord, these are two different things. Either the assessee has to stick with, my lord, that this section is absolutely not applicable in this case. Now, once, my lord, he himself concedes this fact that it is applicable, then, my lord, the applicability of this section leaves a very narrow scope, my lord, for challenging that part of addition or deletion made by the authorities. Because then it becomes, my lord, a disputed question of fact. Therefore, my lord, by virtue of section 260 capital A, it does not give rise to any substantial question of law.
All right.
Because you yourself, you have considered this fact. In paragraph 5, in paragraph 6, 6.7.2,
All right, we'll pass on this.
oblige, Your Lordship.
Should we have also find a bill submission filed before this slightly assumed balance?
Yes, that we have seen.
Deeply oblige. Lord.